Well, thank you everyone for returning for the Q&A session. I'll throw the topic of both papers open for question and answer indiscriminately, but perhaps if you have a question, you can indicate which presenter your question is primarily directed to, but the presenters shouldn't take it that they're confined. If either of them has a view on the question that's posed, then he will make a contribution. Do we have any questions to start with? Well, perhaps I might ask one just to start the ball rolling. I've just recently learned about cloud computing, and I'd be interested to know whether this new privacy regime has an impact on that. Can either of our presenters?
Yeah, I think it's me. Yes, cloud computing undoubtedly has an impact on Privacy Act and the compliance under it. The issue under the APPs is whether an entity discloses personal information. Now, there's an important distinction there. Most of the APPs are use and disclose. We clearly use Dropbox. Do we disclose information to Dropbox? Probably not. So where there are issues of remote cloud storage. Now, does everyone know what I mean when I say cloud? It's the internet at large. I don't know where the service is provided. I don't know where the computers exist. I don't know where the communications run. All I know is that I do things and things happen. So cloud services are an issue because of the requirement of trans-border disclosure. So now for the first time, your clients will care, at least to meet their compliance requirements, will care about where the servers are or where the entities that they're contracting are. That includes things like websites if it holds usernames. So if it's just used, it doesn't matter. But if it's disclosed, that's clearly the case if there is processing. So it would seem that if I have back office functions or I use a piece of software that runs in the cloud where I provide personal information to it, then I have to actually disclose that to my clients in the privacy policy. That distinction is not defined anywhere in the Act. It's likely to be a live distinction, and if anyone thinks it will only apply to big companies, then have a think of people that trade in the internet space. It's possible for a very small business that deals in sensitive information to lose thousands of records from a website hack, and this is where they become vulnerable. So if they're using cloud services, and that involves a disclosure, whatever that means, then they have to put that in their privacy policy. They have to get consent one way or the other.
The other thing, the other thing they need to do is you're meant to ensure that whoever you're disclosing to will abide by the same principles as we do. Now, obviously, that's pretty tough to enforce, but what you've got to do is what your client's got to do is take reasonable steps to do that, and essentially that's by way of contractual indemnity and covenant. So that if you've got a client who's using offshore services of any sort, and I know clients of mine that do data refinement, if you like, offshore in various different jurisdictions, so they'll take their raw data and to sharpen it up and use it better for marketing or other purposes, they have it filtered, and that's done offshore. That has to be disclosed, not necessarily, although I think there's some ambiguity in the principle. You don't have to disclose the party to whom you're putting it, but you are supposed to disclose any jurisdiction where you think it might wind up, so the country, and you then would need to contract with them that they undertake to abide by the Australian privacy principles or equivalents. So that would constitute a reasonable step and a reasonable process which ought to satisfy your obligations under the Act, which are constantly referenced against reasonableness and transparency.
Yeah, a question there.
If you use a software program such as Leap, for example, and where they say they've got it all stored, whether it's in cloud or the older ones, and you discontinue using it for whatever reason, what's your obligation as a lawyer? What's your obligation there? I mean, I've used their software. I've got all the clients' birth dates and whatever. All the letters is all stored in Leap. What happens when I decide not to use it? Sorry, but
there's a positive obligation under the APPs that effectively when the information no longer has a use for which you've obtained consent or you no longer have a business need, then it has to be destroyed or de-identified.
But I can't destroy Leap's records.
No, but what you can do is ask them to do that for you. You can. My reading of this is that there's now an obligation to not just not pay your subscription and let a service lapse, but there is now arguably a requirement to actually write to a past service provider and say, please delete all of the information that I have previously provided for you.
But is there an obligation then to make sure that they've done it? I mean, I don't know how an individual solicitor could...
Well,
the problem here is reasonable steps.
Yeah, that's reasonableness. And that's in the eye of the beholder to some extent.
Yeah.
It's certainly not stipulated.
Going by the published guidelines on reasonable steps, and there is a separate publication on this from the office, you are generally entitled to rely on a contractual obligation of someone else. So if there is a situation where you have Leap, using that example, and you've asked them to remove that information and they say yes, then that would seem to be reasonable and that would seem to be enough. I'm not sure what the answer would be if they said no.
Yes, a question.
In a society where everything is on multiple devices, we've all got the information on our phones and our laptops and everything, and things are quite disposable nowadays. People get rid of them and people lose them. What is the obligation if you were to, for example, lose a smartphone that has all of that information in it, has, emails with affidavits attached to it and all of that sort of thing?
Well, that falls under your obligation generally to maintain network and information security. And so, again, there's no particular specific rules other than you take reasonable steps to do it. And again, there are guidelines of a process that you go through. Essentially, there's a few ways to approach it when you look at the Act, and more particularly when you look at the website. For instance, there are guidelines there about how to do an audit of your organisation, and as part of that there's guidelines about how to audit data and network security and what steps should be in place so that it's defensible, accepting that things happen, you lose phones or your staff do the wrong thing or someone hacks you. What can you do to say, well, I've done a reasonable job of maintaining security notwithstanding that security failed? So it's a bit of a negligence test essentially. Yes. Yeah. But beyond that, I don't think anyone can give you a specific answer.
There are tools available that allow things like remote wiping, or if this computer is taken, for instance, which has Dropbox on it, because I use a thing called BitLocker, it's not something that anyone can just log in and use, or they can't even take the hard drive out and copy it and clone it. Now, I've maybe gone a step beyond what people have to do, but it gives me a satisfaction that if this computer is stolen, despite having confidential information, it cannot be feasibly used. Is that the minimum standard? No. But it would seem that things like password protections, keeping your virus definitions up to date, having firewalls on websites, those days, the days of being ignorant and being allowed to be ignorant of those things, I think are gone. If you're dealing with sensitive information in particular. The little guidance that we have from the office is that the minimum standards would seem to be that your available technologies are kept up to date, and that there is an intention of keeping virus definitions up to date and taking those precautions. But because one of the considerations is the size or the practicality of doing these things, it's not clear for an individual business what reasonable means. And maybe the negligence test is actually a good guideline.
The other thing you can have with employee situations is clients should be revising their employee policies and rules to ensure that there are very clear requirements on employees to respect access codes, passwords, not disclose them, not abuse them, not download material that they shouldn't be downloading. That should all be in there as a matter of policy. One, to ensure privacy and information security, but also as a demonstrable system that's a reasonable step to protect yourself under that sort of regime.
Yes, just on the
Sorry, I just had a question about the new definition of personal information. You mentioned that it's been broadened to an individual who's reasonably identifiable and that now include things like usernames, Skype names. Does that mean that it now includes information from which you can't deduce a person's name or face? For example, if there's a username that doesn't actually include a person's name, is that still considered personal information?
Certainly, it can include. I'll see if I'll pop it up. Certainly, it can include something that is not a name or a face. All you need to have is sufficient information that an individual, and that's the critical test, can be reasonably identified. So take the example of, the description I gave before, the big guy with glasses and a beard that presented this morning. That actually meets the definition, because you're able to fix something that can then identify me. Right? That description is unique to me in this room right now. That's personal information. Name and face weren't included. But you can take it as read that a name or a face is personal information. The question is, what is reasonable outside of that? And all I can suggest is, if you can piece it together from information that's available to someone such as Google, then that becomes personal information. Does that answer the question?
Kind of. Do you still essentially need to be able to deduce a person's name or face from that piece of information?
No, you don't need to, but if you can, then it's personal information, and it's information you therefore have an obligation for.
I mean, the definition sort of disappears into itself a bit, because it actually says it can be information or an opinion, and whether it's recorded in material form or not. Well, I'm not sure how you're supposed to protect or deal with an opinion that's not in material form under the Act. I mean, it's just... So, one is left a bit nonplussed, I think is the fair thing to say. Antoine?
Actually, I'll follow on from the previous question, a question for the big guy with the beard and the glasses. Our smartphones are increasingly promiscuous. Yeah. They provide information to various service providers with or without our knowledge, often without. Increasingly, there are some new technologies being touted about, particularly in the retail space. Beacon technology, Bluetooth, like short-range technology that allows effectively an interaction between the smartphone and the beacon within a range of, say, 2 metres. Effectively, I could be walking through my through my supermarket, or even a shopping centre. Let's use a shopping centre. We'll know that I went to a supermarket, a news agency. We may even be able to know, not I, but my phone did. Yes. That my phone went to Maya, stood at the homewares department for 5 minutes. Subsequently, it stood near a cash register at a particular time, and a purchase was made at that cash register, and it might have been through the phone itself. Now, all that's really being disclosed is potentially the IMEI of the MAC address or a particular identifier with regard to the phone. Discuss.
Well, first up, the fact of a purchase is not enough to identify someone.
No.
It is the aggregation of the information that you described that creates the problem.
Indeed.
and if that aggregation is not enough to reasonably identify me under the Act, then it clearly is not itself covered.
Okay.
The question becomes what reasonable is.
Yes.
And I, clearly, if I was standing at the cash register at the time, you've just given me enough information to identify that not just that it was one of these 15 people, but it was you.
Correct.
And that's there. This whole area, I'm not going to answer the question because there is no answer.
There is not.
Other than you need to worry. If you're a business that is built on infonomics, where you're selling and aggregating information and where you're mining information to add value from otherwise disparate facts, then these things are real issues and they need to be looked at, and they have not been properly thought out. And at the time that the ALRC did their review and report this is based on, which is only 6 years ago, these businesses effectively didn't exist. But I will say I was involved in a project once that I'm not allowed to name in the 90s that had the ability to identify someone walking past an ATM machine and target a message audibly to that person, knowing that they were likely candidates for a home loan or a credit extension or something else that would attract them to that particular ATM machine and so on. This is technology that was groundbreaking at the time, that was first deployed in Tokyo. From there. So the idea of targeting has been around a long time, but the idea of being able to aggregate across many, many businesses and put it together and get concrete business advantage and sell it is new.
Although, in that scenario, the person collecting the information has a very explicit obligation to let you know that they have collected it and how they've collected it and what they propose to do with it. And they have to keep that, then obtain your consent, unless it's reasonable not to, which it's unlikely ever to be given much rein, that proposition. And they've got to maintain that consent up to date. So you can't just get it once and keep it forever. There's got to be refreshed and reused. And once they no longer have a purpose, which they've disclosed, they've got an obligation to get rid of it. So for clients that are doing this, there are now a broad range of requirements from the what I call the threshold moment where you get that information about disclosing that you're getting it and what you're going to do with it. And I don't think it's enough, personally, in reading the way it's framed, to just say we've got a privacy policy, go and read that. I don't think that's sufficient. You've got to be able to say a bit more, maybe not a whole lot more, but you've got to say this is who we are, we're collecting your information, these are the sorts of uses we're going to put it to, here's our privacy policy, in there you'll find out how to complain or otherwise. And then you've still got to maintain some sort of audit on the information you've got and how fresh it is, how relevant it is. And that's a whole new level of internal process that I don't know that a lot of organisations have even contemplated yet.
Just on the question of consent in your specific example of Beacon, any of you that go to a shopping centre and use the free Wi-Fi, have a look at the terms and conditions, because they allow precisely that. Right? They allow you to be tracked. They allow a lot of your movement and actions and so on to actually be collated, and you think you're getting free Wi-Fi.
Now, of course,
actually selling information.
Yeah, but of course, part of this will come back to complaint. I mean, the Commissioner can kick off his own investigations, but a lot of it will come back to complaint. And in the end, I think we'll probably get a generation growing under this level of scrutiny that isn't necessarily going to complain all that much about it. Yeah. So while we sit here being sort of horrified, it may be that that's theoretical rather than actual, depending on the level of pushback that people get. Yeah. Although you're seeing some big cases, there's Google in trouble in the States and in Europe recently, so maybe there's more pushback than we think.
And there was a survey done last year by the office that showed that adjusted across the cross-section of the population, despite us thinking that Gen Z really don't care about this information, they actually do. They might not think at the time that they post the drunken orgy on Facebook that might be a future problem, but they certainly will later come to regret that. And there is a significant percentage of the population, which no doubt will include a third of the room, that are concerned about information they've already posted.
Yeah. Sorry, another question.
Just one more. Sorry, I'm not on Facebook, but what sometimes in family law matters, people put wrong photos on Facebook. I've got a case at the moment. And what happens if they say they take it off or whatever, and that photo still remains there? Are they responsible?
Sorry, that Facebook say they'll...
Yeah.
Sorry, you were saying that Facebook say that they
Well,
won't take it off?
no, the client is ordered to take that picture off Facebook.
The client is almost certainly not covered under the Act, because one of the carve-outs is when they're acting in their personal capacity. So it has to be in the context of a business.
So the lawyer who has that picture on Facebook would be responsible for that, but not the client.
I've got no easy...
Unlikely.
It sounds
Sounds
unlikely.
unlikely.
Yeah.
But it just depends on the circumstance. Very hard to think how that would be covered by.
If I might just touch on something that something that occurred to me while Simon was speaking a moment ago. Perhaps I could ask each of the presenters to comment on the practical opportunities and areas of activity that this new regime offers to practitioners, because I imagine that's what most of the people in this room are interested in.
I'll just quickly say there's vast work to be done, almost too much. I think clients are maybe potentially going to go into their shells a bit when they think about what's actually entailed here. But certainly I think the starting point is to review the privacy policies, which will need to be redrafted if they've got one, and to review that sort of threshold disclosure, I think is a crucial thing. If you get that right, if you get your consent propositions right, which is telling them that you're collecting, telling them what you're collecting, telling them purpose, and saying obtaining consent. Now it can be consent by inference or it can be explicit. But if you can put that in place, consent is king. Consent will excuse virtually everything. So that's what you've got to do, is get good quality consents in place. That's my view.
Yeah. As it happens, I've just got bullet points in my paper on this, hence the apparent pre-preparation of the slide. I think there's actually significant opportunity for the people in the room to actually assist their clients in compliance in this area. It actually starts with asking the question of, are your clients covered under the scheme of the Act? Remember those carve-outs. So if they're business clients but they deal with sensitive information, they provide a health service or any of those other exceptions, it doesn't matter what size they are. So I think it's almost, well, incumbent might not be the right word, but it's certainly available to us that in the interests of our clients that we actually explore enough about them, and we normally would know, to see whether they come within the scheme of the Act, and if they do, to then take the next step, as Simon has just said, do they have a policy, do they comply, what do they deal with? This scary new world of reasonable steps, of having to actually implement a policy, not just have a policy. Most of your clients will have a website. Is that a minefield for them or not? You don't know until you find out, does it store personal information or does it transit through? Opportunities for audits and so on are there. There are law firms out there that are advertising fixed price review programs. Norton Rose comes to mind. $5,000 gets you 1 hour of their time and a template policy, and copies of freely available material that sits on the office website. From that, any business that has IT, any business that has cloud components in the way they deliver the services or the way they perform their business, they are all clients that are at risk. They're all clients where everyone in this room has the ability to assist one way or the other with them in that. I also mentioned that if an individual comes to you concerned about privacy, Simon's mentioned that there is a regime, and he's mentioned that there are injunctions available under the Act as well. That also starts with the question, if you take Ella's case, is the information even covered under the Act? From there, but there are ways you can assist individuals as well under this Act.
Are there any further questions? Well, I'll thank you all for your attendance. It's been quite a stimulating discussion in an area that, as our presenters have said, is somewhat terrifying in its complexity, and I hope that everyone goes away with some greater understanding of the issues and what to do about them. So I'd ask you just to thank our presenters in the usual way.